Guys, it's your favorite federal informant. Listen, you guys, I am on vacation, but I wanted to pop in and talk about this thing that's going on. I know you guys heard about it, a lot of people have questions. I wanted to come and address it. If you guys don't know, did he tell the defense in the prosecution that he wants them both to turn in, similar case like Diddy's? Okay, and by similar, it means you got convicted of one or two things of the main act, and you had the criminal priors. Now, a lot of the Diddy goons, the Diddy idiots, were like, oh, did he go for a walk? He hasn't even been doing jail time. To which I said, okay, stop. Okay, Diddy might have beaten Rico. And it was a crushing go. It was a crushing blow to victims, to women, for anybody that doesn't stand with abuse, right? Did he beat Rico? But there's more to that story. But let's stick to the topic. And apparently, jury said, we don't care what happened with Jane and Cassie, but because you were their boyfriend or their man, I guess you own them, and you can do what you want. However, the one thing that kept and no longer has a voice who will pursue justice for her accusation onto majors of the Diddy, no expansion of the investigation, no isolation orders, no equipment access, no suspension of paternity communication. This is going to be good. Okay, now, what did the judge ask for? He asked for comparable case law or statistics on similar main convictions. Now, first of all, this request is not unusual, but it is never neutral. It usually signals one or two things. One, that the judge is exploring options to justify a lighter sentence or release, especially if they're asking about parole eligibility, probation, or sentencing ranges. Two, the judge is building a case for why Diddy should not get leniency. By establishing how others were treated in similar cases, they could argue that letting Diddy off lightly would be inconsistent or unjustified. So the big question, alright, I'm actually being texted like to sir, so the big question is what context the judge asks us in. And the thing is, if we look at the Diddy case, this is where things get tricky. The judge has already denied Bell and Cala Diddy is violent. He read him to filth. The judge was not happy, okay? And said his community ties made him more dangerous. Not so. It's going to be hard for Diddy to rebrand himself. The judge also has letters from multiple victims who explicitly said he's a threat and allegedly wielded violence as a means of control. Diddy has access to money and potential leverage over witnesses, and the judges don't like to be made a fool of. And if Diddy walks and does something shady again, and I think he actually will do something shady again, it reflects directly on the court. And you guys listen, the verdict of the jury threw us for a loop. But the fact that judge said all this in court, and deny bail. I mean, come on, I think we can put two and two together. This does not look like Simeone that's looking to cut Diddy a break and him being able to walk straight with time serve. Baby, that's cutting Diddy a break. Okay, so why ask? About the comparable man act sentences? Okay, they said, listen, Tessa, there's three possible reasons. One, judicial covert. The judge might personally feel parole is risky, but is giving the appearance of objectivity by asking both sides for precedence. That way no one can claim bias later. Now, he might be appealing his decision for when he sentences him. If Diddy's team appeals any eventual sentence, the judge can say I've reviewed the sentencing ranges and outcomes for similarly situated defendants under the Mon Act and the sentence falls squarely within that range, or the judge also might be testing boundary. Maybe the judge is trying to find out how lenient or harsh they can go without being reversed. They could be considering probation in theory, but still leaning towards prison unless Diddy's team provides extra mitigating evidence. Now, let's talk about that mitigating evidence. Remember when I told you guys that Diddy's team, I believe, are trying to shut up any content creators that are still criminal with them. And they feel like if they shut down the content creators, then they can start on this .rebrand. Think about it. You shut us up by July, August, and September, and then y'all get a little bit of October to get this Mother Teresa Hail Mary that they think is going to wipe Diddy's record clean. Unfortunately, a lot of evidence that jury wasn't sure, a lot of witness estimates and affidavits that the jury didn't see. The judge is privy to all that, and all that is going into his decision. Okay, so again, I said, but do you really think there is any type of risk of Diddy walking with just parole? I said, no, but I had to take it to the people that actually practice law, and they said right now, Tessa, it is super low, and I'm like, okay, but why? Because you all also said it was super low that he was going to beat the Rico charger. Well, that's not true. They said the Cassie charges were super low. They said, 1. The man acted as a serious federal charge. And even though it's sometimes used strategically in civil or hybrid cases, judges take it very seriously when paired with violence and pattern behavior. Judge Arn, when did he ask for bail? He said, not only is he violent, but there is a pattern of violence, public sentiment. They also will take this. It's low because of public sentiment and visibility are sky high, and the DOJ knows this is a credibility test. Again, remember Marine? Comey said this is chilling for victims. It will have a chilling effect. And if Judge already said Diddy is violent and a threat and denied bail, and then suddenly letting him walk would make the judge looks wildly inconsistent unless new facts came to light. So what do we think about the judge and no longer has a voice who will pursue justice for her accusation if there's any legal wiggle of the taken against no expansion of the investigation, no isolation orders, no equipment access, no suspension of faternity communication he's already decided on. So unless Diddy pulls a Lego rabbit off the hat, he's unlikely to walk with this parole. This request is probably more about sentencing justific than leaning okay so here's the thing, right? Okay, what type of language? And I just want to refresh your memory. The type of language that slams the door on parole or probation. And listen, let's get into this. He stated he was a batterer. This is not just commentary, that is legal language. Or is it suggests a pattern of violence, not a on-time incident? And the judge is accepting allegations as credible and may be treating them as established facts for purposes of sentencing or bail decision. And it undercuts any claim that did violent behavior is isolated, provoked, or misunderstood. Judges should casually just not throw out that word unless they want it to stick around on the official record. He also said your client admitted he is violent and tried to preemptively enter a better program. This is huge because of sentencing rehabilitation. It's like enrolling in a batterer programs are often seen by judges as damage control and not sincere reform. The fact that Diddy knew to enroll in that program shows consciousness of guilt. He anticipated legal trouble, admission of violence undercuts and he didn't do it. Or this was exaggerated. Def, and if the judge believes the mission wasn't just PR but rooted in truth, it justifies custodial sentencing over any community supervision. Okay. Now, also, the judge said this type of violence comes suddenly, quickly, and with no warning. That's a judicial finding of dangerousness. They said that phrasing means that the judge believes that he is not in control of his violence and that his behavior escalates. It's impulsive and it's unpredictable. Judges use this language to justify detention, especially in Baylor's sentencing memo. It also implies that even if he's calmed down, he could explode at any moment, which is true, and we can't risk that in the community. That is a direct argument against probation. Now, when you hear all that, I have to ask you, does this sound like a judge that's going to let Diddy mean? Let's be serious. Even though I'm scared for the Diddy goons, what are they going to do? Hold a visualized standing outside with a boom box begging for him to be let out of jail. I can't wait to see this. They said so again. I don't think it'll actually, absolutely not. If anything, a judge is building a sentencing record that says even if this man has money, power, and influence, he is violent, is dangerous, and he is incapable of safely existing in the community. Had tried to game the system with a batter bro. He admitted what he did, and I'm not playing along. Again, these estimates make it legally and politically almost impossible for the judge to grant parole without massive backlash or risk. If Diddy reoffends or contacts a victim after release, it's on the court. This isn't a judge looking for an excuse to show mercy. It's a judge locking in a narrative of violence, manipulation, and danger. Any future sentencing or probation denial can be backed by this exact language. So unless something drastic changes, probation or parole is extremely unlikely. You're watching a legal system slowly setting the foundation for a multi-year custodial sentence, or at the very least strictly monitored. Okay, as strictly monitored, movements. Again, listen, at the end of the day, I don't know. It is what it were expecting that Diddy will actually do some jail time. I don't think that the judge is actually going to take the time and go through all this and make all these notes just to let him out in public. Now, will Diddy really offend? That's a different effect. I'd 100% think he's present. Thinks he will. But you never know. Maybe in Mark Agnifilio's loving arms, he has found a new version of himself because we know that Mark is doing its best to uplift that man. Anyway, you all let me know what you think in the comments. I'll talk to you all later, okay?